the end because maybe I'm not speaking sufficiently clear for you. So whenever you have questions, you can raise your hand or start your microphone. Now I'll try to share my slides and oh, here it is. You see the slides?
Yes.
Okay. So the topic is euthanasia, as Anna was mentioning. And let me just start by saying that there are two different kinds of intentional termination of a patient's life that must be distinguished, and they must be contrasted with something else, which is the withholding or withdrawing of medical treatment. Now, the two kinds of intentional termination of patient's life are, on the one hand, active euthanasia, which is the intentional causation of death by a doctor, and the other one is physician-assisted suicide, which is the intentional causation of the patient's death by the patient himself or herself. This includes the doctor's help, that is, the doctor prescribes, for example, drugs or procures the means to bring about death, but the agency is in the hands of the patient himself. Now, these two things, these two kinds of intentional termination of a patient's life must be contrasted with a third thing, which is the withholding and withdrawing of medical treatment, which is the act by the doctor to comply with the patient's refusal of treatment. Now, in the first two cases, there is an explicit intention to kill, and the act is intended to procure death. In the third case, the intention has to do with complying with the refusal of treatment, not imposing unwanted treatment. So the distinction is based on the different principles that are involved. In active euthanasia and physician-assisted suicide, PAS is physician-assisted suicide, the guiding principle is that the patient has a right that her life be terminated, either by an act by the doctor or by an act by the patient himself or herself. Whereas in withholding or withdrawing medical treatment, the guiding principle is different. It is the fact that the patient has a right to refuse any treatment which she deems disproportionate, excessive, unreasonable, or that she simply does not want. So this is the basic difference between the two, on the one hand, active euthanasia and physician-assisted suicide, and withholding, withdrawing medical treatment on the other hand. Now, this second principle, the principle according to which you can refuse any treatment you simply don't want, has been entirely accepted by the Italian legislation through Act 219 of 4 years ago, 2017. Article 1, in particular, very clearly accepts what in bioethics is called the principle of autonomy or self-determination. That is the idea that no treatment is allowed without the patient's consent, and that the therapeutic relationship is based on consent. This also implies, of course, and the law very clearly says this, that the patient has a right to be told the truth concerning his or her condition, has a right to know, and of course, she also has a right not to know. Maybe sometimes the patient does not want to know, but he has to tell the doctor that he does not want to know. Maybe tell to my family, tell to my wife, tell to my daughter or son. But if the patient does say nothing about that, the patient has a right to know, so the doctor must disclose every information concerning therapies, outcomes, prognosis, and so on and so forth to the patient. Moreover, Article 1 of this Act 2019 also has a right, also says that the patient has a right to refuse all treatments, including those treatments such as, for example, mechanical ventilation, the interruption of which causes death or is very likely to cause death in a short while. But the law does not say that the patient has a right that his life be terminated. The law just says that the patient has a right to refuse treatments. So it is clearly embraced a principle of therapeutic refusal, but the law does clearly exclude the idea of directly causing a patient's death through, for example, a lethal injection, either activated by the doctor or activated by the patient himself through the doctor's help. In fact, Article 1 also says that while the physician must respect the patient's wishes, the patient, on the other hand, cannot require from the doctor any treatment which is against the law. And this is an implicit reference to the two articles of the Penal Code which are relevant for our topic. The two articles, as mentioned by Anna, are Article 579 and Article 580. The first is entitled Murder of a Consenting Person. This is very similar to what we call euthanasia, but is much more general because it does not include only the active termination of life caused by a doctor, but by anyone who kills someone who wants to be killed is punishable up to 15 years of imprisonment. And rules on first-degree murder apply if the victim is a minor or mentally ill, or if consent was extorted. The second type of offense is covered by Article 580, which is called inducement or help in suicide. And this is very similar to physician-assisted suicide, but as for the first article, this does not include only what is being done by a doctor, a medical doctor, but by anyone who convinces another or helps another in committing suicide is punished up to 12 years of imprisonment, and this penalty is increased if the victim is a minor or mentally ill. If the minor is less than 14 years old. Rules on first-degree murder must be applied, which means up to 21 years of imprisonment, because it is presumed that a minor who is younger than 14 is unable to make a decision by herself. So, is everything clear up to now? Sorry, I have. Can you still hear me?
Yes.
Okay. Because when I share the screen, I can see no one, no more. So I'm not sure that everyone is still hearing me. Okay. Let's go back to the slides. Can you see them? Yeah.
Yes.
Okay. So this topic has started to change, and the discussion in bioethics and in also in legal studies has been enlightened by the so-called DJ Fabo case or Cappato case. This slide had to do with the international legislation, but now we concentrate on Italy. But just to remember that there are a few, 5 countries in the world in which euthanasia is accepted, and only voluntary euthanasia is accepted. That is the request made by a competent patient of being killed, and physician-assisted suicide is legal in these 5 countries: Netherlands, Belgium, Luxembourg, Canada, and Spain, and is also legal in some other countries such as Switzerland, Colombia, Victoria, and some of the US states. Now, let's go to the DJ Fabo case. Fabo is the nickname of Fabiano Antoniani, who was a DJ, and he was a 40-year-old man. He was quadriplegic and blind after a severe car accident. He was partly dependent on artificial respiration, and he made up his mind by himself, totally by himself, that he wanted to die, and his relatives did not agree with them, but they supported him. And in February 2017, Marco Cappato, who is an Italian politician and an activist for the right to die, brought him to Switzerland by car, and Fabiano Antoniani was helped to die in an exit clinic in Switzerland. Now, the case was brought to the public attention because upon coming back to Milan, Marco Cappato went by himself to the public prosecutor's office. He denounced himself because he wanted to mount a legal case against the Italian law. Because the Italian law, as you have seen, Article 580, censures physician-assisted suicide. So he wanted to open the road for a legal change by mounting a legal case against himself. So it was a sort of case of civil disobedience, in a sense. Now, the case went to the court in Milan, and the Milan tribunal challenged the constitutionality of Article 580, which means that the tribunal did not say, well, Cappato is not punishable because what he did is not against the law. No, the court said what he did is against the law, but the law is wrong. The law is unconstitutional, and therefore the Supreme Court, which is in Italy is the Constitutional Court, was charged with deciding whether Article 580 is or is not conformable to the principles of the Italian Constitution. And on September 2019, the Constitutional Court gave her ruling 242, and the court said that Article 580 is not unconstitutional because the Milan Tribunal is wrong in suggesting that Article 2 or perhaps Article 13 of the Italian Constitution entail a right to die. Just to be clear, Article 2 only talks about human rights in general. It says that the Constitution acknowledges human rights, but according to the Constitutional Court, the right to die is not among the human rights, and in fact is never mentioned, for example, in the Universal Declaration on Human Rights. And Article 13 of the Italian Constitution says that no one can violate liberty. Liberty is inviolable. But this, according to the Constitutional Court, does not entail that one has the right to die. So this norm is constitutionally acceptable because it is important, the court says, it is important that we as a society protect vulnerable people from the consequences of certain decisions which may be sometimes irrational and are definitely irreparable, such as the decision to kill oneself. It is true that in this way we act a little bit paternalistically. I mean, the law protects the individual against him or herself. But the court says that we should not be misled by certain views of self-determination or autonomy that totally ignore the conditions of despair and helplessness in which certain decisions are taken. So this is the first part of the ruling, which defends Article 580 from the charge that was mounted by the Milan court against the constitutionality of Article 580. However, the ruling goes on to say that there are cases, such as the one that they are deciding, the Cappato case or the DJ Fabo case, in which if someone aids another in committing suicide when this other is a patient who is still competent to make a decision for herself or himself, and moreover as an irreversible disease, thirdly as a disease that causes relevant suffering, and fourthly as a disease that implies dependence on artificial means of life prolongation. So if these four conditions obtain, then the one who helps in committing suicide cannot be punished. So the Article 580 should be modified in order to allow such cases to occur without legal prosecution of the one who aids in committing suicide. So the court says in such cases, finding someone who helps in committing suicide may be for the patient the only way out from an artificial prolongation of life that the patient no longer wants, and that the patient has a right to refuse, because Article 32 of the Constitution says that no one can be obliged to any medical treatment unless there is a law that clearly states, that clearly declares that that treatment uh, uh, is compulsory. And typically we refer to vaccination. There is a list, and there must be a law that lists the vaccinations which are compulsory for everyone. So here, however, there is a possible objection, and the Constitutional Court has dealt with the objection. And the objection has to do with the fact that Act 2019, of which I was talking before, very clearly allows patients to be, we say, allowed to die, not to be killed, but to be allowed to die. Because the patient who are permanently dependent on life-sustaining technology are allowed to remove the life-sustaining treatment. And by removing all treatment, they can be allowed to die. And of course, they can also have recourse to terminal sedation, that is, they can be put to sleep. For example, because if you remove the mechanical ventilation, then you will experience dyspnea, but you will not if you receive terminal sedation. That is, you sleep and you wait until you die. So it is not true. So the objection goes. It is not true. Physician-assisted suicide. He could avail of the provision of Article 1 of the Act 2019, be terminally sedated, remove all treatment, and be allowed to die. So why should he have had the right to receive physician-assisted suicide? The court has replied to the objection in this way. They said this option is in fact one possibility, but this implies a slower process of dying, and this may be incompatible with the patient's conception of dignity. And in fact, Fabo had considered this opinion, this possibility, and he had said, no, this is not a good death for me because it would take a longer time. It was speculated that he perhaps needed 2 or 3 days to die in that way if they had removed anything. And this would be more painful, particularly for the patient's relatives and friends. So he did not want to die in that way. He wanted to receive an intervention that could bring about his death immediately, so to say. And this is in fact what he received in Switzerland. So the court concluded in its ruling that Article 580 in its present formulation violates the patient's freedom in autonomously choosing therapies. This freedom, according to the court, is warranted by Articles 2, 13, and 32 of the Constitution. It is true that a specific protection must be given to vulnerable people, so Article 580 is constitutionally okay, but not in its present form, because it must allow for these cases in which a patient has no other option than having recourse to physician-assisted suicide. And the court says if the patient is competent to refuse life-sustaining treatments, then he or she must be considered competent to request physician-assisted suicide as well. And so in such cases, when a patient is very clearly competent, wants to die, and is suffering, has an irreversible disease, is dependent on life-sustaining technology, then physician-assisted suicide cannot be illegal, cannot be punished. Is this sufficiently clear up to now for everyone?
Yes, it's clear. Thank you.
Okay. Now, we may raise some objections to the court's decision, and some commentators have raised some objections, and I'm very sympathetic to some of the objections. We can try to reason in this way. First, the court has explicitly denied that a right to die exists. There is a right to life, but the right to life does not entail the right to be helped in dying. Quite the contrary. Now, Law 2219 does protect the right to make choices on medical treatments. But the objection is to obtain a lethal injection from the physician, from the doctor, can be equated to obtaining a medical treatment. I think not. Obtaining a lethal injection, even though perhaps activated by the patient himself, as it happened in Switzerland, obtaining a lethal injection is not obtaining a medical treatment. It is obtaining the termination of life. So when you simply say, I no longer want to be cured, I no longer want mechanical ventilation, you're making a decision concerning therapies. But when you say, I want a lethal injection, then you are making a decision concerning death. So the two principles that we saw at the beginning here have been, it seems to me, conflated by the court, so that the court has extended the principle of self-determination from a decision concerning therapies, which is very clearly justified in light of Article 32 of the Constitution, to a decision concerning death. It has granted, so to say, to lethal injection the status of medical treatment. And this is questionable, in my opinion. The second observation is this, that if you protect, as the ruling by the court seems to protect the patient's choice of death, not a choice concerning therapies, but a choice concerning death. If you protect the patient's autonomy in choosing death, then you are accepting a principle which opens the way, on the one side, on those risky influences on decisions of vulnerable patients that the court wanted to avoid. The first part of the ruling said this: we have to protect vulnerable patients. And secondly, if you substantially accept this principle, that you can make a decision concerning death, and you must be helped in making your decision concerning death, then there is no reason why you should not question Article 579 as well. So at the end of the day or at the end of the road, if you move in that direction, you should move towards the legalization of active euthanasia, because at the levels of principles, there is no longer any difference between accepting physician-assisted suicide on the basis of the principles set by the court and accepting at least certain cases of voluntary active euthanasia. And this is exactly what has been proposed by the people who have gathered the signatures for proposing a referendum concerning Article 579. And this is the entire wording of the article as it is now. What the proposal consists in is the effacing, the canceling of those words that you see that are cancelled in the slides. The slide has a mistake in English grammar, simply because I wanted to keep the Italian wording. So the wording is, anyone who causes the death of someone with his or her consent is punished with imprisonment from 6 to 15 years. Aggravating factors of Article 61 are not applicable. Then it says, in Italian it says, si applicano le norme relative all'omicidio. So it would be norms relative to murder must be applied. But I put must be applied before, because so you can see very clearly how it becomes with the proposal of a referendum. The proposal is to cancel the words from imprisonment to applied, so that the article becomes, anyone who causes the death of someone with his or her consent is punished with the norms relative to murder, if the case concerns someone who is younger than 18, someone who is mentally ill or is in a condition of psychic deficiency because of some other disease or because of alcohol or drug abuse. Thirdly, a person whose consent was extorted with violence, threat, or deceit. So the article would be changed from a norm that punishes everyone who causes the death of someone who wants to die and who has much more severe norms in these three cases, to an article that simply accepts all kinds of active termination of life of one who wants to die, but except for those three cases that are listed. These three cases are the only three cases which are not accepted and are punished very severely, as if it was simply murder. Is this sufficiently clear, or should I go into that a little bit more?
Yes, I just wanted to ask, is this specifically referring to patients? So, like
yeah, this is a great
killing. Pass me the term. This
is a great question, and my next slide is going to give the answer. My comment, my basic comment on the proposal is that this is a far too wide acceptance of the principle of euthanasia, because all the laws that we saw, there are 5 countries in the world that have laws that accept euthanasia, but all these countries regulate euthanasia with several conditions that must be followed for an active termination of life by a doctor to be acceptable. Now, if the referendum was passed, the Italian law would be in this way. Anyone who causes the death of someone is punished with the norms relative to murder in these three cases, and in all other cases, no punishment at all, no possibility to say that this is wrong. And this means, as you were implying with your question, that the Italian law would not require that the act be performed by a doctor. Second, that the Italian law would not require that the person be sick. I mean, if you reread the wording of the article, anyone who causes the death of someone with his or her consent, it is not said that this someone must be a patient. It is not said that this someone must be physically suffering. It is not said that this someone must be terminally ill or dependent from life-sustaining treatment. This someone must simply be one who wants to die. And if he or she wants to die, then that is okay. But all laws accepting voluntary active euthanasia provide for several conditions, such as that the person must be a patient, physically suffering. Sometimes it is also said that he or she must be terminally ill, not always, but very often it is also required that the individual must be dependent from life-sustaining treatments. Moreover, for example, the Dutch law requires consultation from another doctor. You cannot simply say you, the doctor, say this patient suffers, as no other therapeutic opportunities, the pain is intractable. Well, you can say this, but another doctor must confirm, who is not involved in the care of your patient, must confirm that everything you are saying is really in the way you say. So you need a consultation from another doctor. You need the condition in which no alternative therapeutic measures can be attempted. So the proposal would sanction, in my opinion, a very broad, a much too broad acceptance of voluntary active euthanasia. And
can I ask a question, Professor? I'm
Yeah.
sure the associations that proposed the referendum text have studied the topic. So my question: why would they have written it in such a broad and kind of precise way?
Great question. It is clear why they did. Of course, they studied the topic, and of course, they have lawyers to consult them. But there are two elements that must be kept in mind. First, in Italy, we have the institute of the referendum, but the referendum is only abrogative nature, which means that you cannot create a new law by a referendum. You cannot create a new legal principle by a referendum. You can only cancel a rule, cancel a norm. You can cancel something. So what they could do is simply, in a way, manipulate that article 579 in order to make it say something different from what it said before, by canceling certain words. They cannot substitute new words. For example, they cannot cancel those words and, for example, also put down the conditions. For example, anyone who kills a sick or a terminally ill patient or someone who is depending on life-sustaining technology, they cannot use these words. They can only cancel words. So this is the first thing to note and to keep in mind. And the second one is that they know very well that the article, as it would become if the referendum was passed, would not be really acceptable. But they proposed the referendum nonetheless because they wanted to, in a way, give a shock to the parliament, because the Constitutional Court had already announced the ruling of October 2019 in September 2018, but it had given the parliament a year to think about the matter and to produce something that could much more with much more definition try to take into consideration all the conditions that must be applied, for example, for physician-assisted suicide. But the parliament did nothing. And the parliament has very often, the Italian parliament has very often shown substantial indifference or perhaps lack of courage in tackling these very complex and difficult problems of today's medicine. So I guess they decided to propose the referendum as it is. They perfectly knew that the resulting norm would be very much objectionable, but by the referendum they want to put pressure on the parliament so that the parliament is going to tackle the issue. And eventually, when the referendum will be passed, they say the parliament will have time to make a new law that defines very clearly the conditions, and there we will have only the very general principle, but then the parliament will have to make a law. So this is the answer to your important question. Of course, there can be reason for being skeptical a little bit. Why? Precisely because the parliament has very often been scarcely active on these matters. For example, the law on advanced directives for treatment, which is a provision contained in the law of December 2017, well, they have taken 20 years of discussion before approving that law. So it is a bit problematic, I think, to say, okay, we can pass the referendum in this and have this norm changed, and then the parliament will make up for the problems, will define conditions through a new law. This is a bit worrisome because it is not clear that the patient will be so rapid in tackling the problem. And one more point that must be stressed is that the hypothetical passing of the referendum, so that once you have changed Article 579 in that way, then we are going to have a very, very strange condition. a situation in which physician-assisted suicide would be very strictly limited because the Constitutional Court has posed 4 very strict conditions for the acceptance of physician-assisted suicide. And on the other hand, voluntary active euthanasia would be almost limitless. And this would be clearly inconsistent because physician-assisted suicide is in a way much less problematic in the sense that, as we said, agency is very clearly in the hands of the patient, whereas in voluntary active euthanasia, agency is in the hands of the doctor, and if the referendum is passed, in the hands of anyone who accepts to kill another individual. And this second thing is much more problematic, of course, because there is room for several situations in which we would not want to accept that someone kills another. So it would be very strange that we have strict limitations for physician-assisted suicide and no limitations at all for voluntary active euthanasia. And this is one of the reasons why the Constitutional Court may declare the referendum unacceptable. You know, or perhaps you don't, but the Constitutional Court has to give a decision as to the acceptability of the referendum. It happens at any time. Whenever you propose a referendum, there is a judgment by the Constitutional Court that says, okay, the people can be called to give their opinion on that. And one of the reasons why the Constitutional Court sometimes has said no, this matter cannot be decided by the referendum is the fact that the resulting norm is partly inconsistent or somehow not working. So this might be a reason for the Constitutional Court to declare that the referendum cannot be acceptable. And another reason might be that the proposal is somehow manipulative. The Constitutional Court has already said in past years that certain referendum were manipulative. And in fact, in this sense, here we have a manipulation of the article because the rationale of the article is totally changed from a strict duty not to help in killing another to a very broad acceptance of the principle of voluntary euthanasia. And so it seems that a sort of new legal principle is introduced, and or at least this may be argued by the Constitutional Court. I don't know what the Constitutional Court will say. Perhaps the Constitutional Court will say that the referendum is okay, and so all this stuff is vanished. But the point is that, as I said, the referendum should only be abrogative, while it may be claimed that this referendum is somehow a proposal of something new and not an abrogation of something that exists. But we will see. The Constitutional Court has time, if I am not wrong, up to February to decide, and then it will say if the referendum is acceptable or not, and if it is, then we will have the referendum in spring next year, and otherwise, of course, there will be no referendum. Now, I would like to conclude. Do we have some more minutes?
Yes, no problem.
Okay, so I will take some 5 or perhaps 10 minutes just to give a very short review of the arguments in favor and against euthanasia and physician-assisted suicide, because I mean, you may say, okay, this referendum perhaps is not the best means to reach a law which is reasonable and acceptable, but in principle, should we accept euthanasia and assisted suicide or not? Now, of course, there are arguments both in favor and against these things, and I will just review them very briefly. There are two basic arguments in favor of euthanasia and assisted suicide, and the first argument is the argument from autonomy. The idea that is that all competent persons, that is, people who can make decisions by themselves, are free to decide when to terminate their life, because they have a conception of what a good life is, and they have a conception of what a dignified death is, and they must be free to follow their conceptions. So this is a very generally liberal conception according to which individuals should be allowed to do whatever they want to, so long as they do not cause harm to others, at least direct and ascertainable harm to others. So according to this view, it is always wrong to interfere with another's rights to act according to her values, according to her belief, according to her conception of what a good or dignified death is. This is a very straightforward and very clear liberal argument, and it is centered on voluntary active euthanasia. The element of voluntariness is fundamental here, because the basic consideration is the patient's actual wish to die. There is a second argument which centers, on the other hand, on beneficence. That is, the idea that the patient would be better off dead because the patient is suffering too much, and such suffering is incoercible. And so here the reason is not so much that the patient wants to die. Of course, the patient also wants to die, but the real reason is that we have to spare this suffering to the patient. And this is a sort of different argument. This is what we in moral philosophy we call a consequentialist argument. I mean, an argument that makes rightness, what it is right to do, a function of the consequences that your action produces. So on this account, the only thing that counts, morally speaking, is the total sum of consequences that you create by your action. Therefore, according to this view, an act is right not if it, for example, respects the rights of individuals. It does not look at rights. It looks at consequences. So an act is right if the if with two F's is used by logicians to say if and only if. So an act is right if and only if it maximizes good consequences for all the individuals involved. So this argument is much more broad in its acceptance of euthanasia and physicians assisted suicide, because it may also justify non-voluntary active euthanasia, not only voluntary active euthanasia. Because imagine, for example, a patient who is not competent, is no longer competent. For example, a patient who has dementia or Alzheimer's disease, or is in a vegetative state, and let's imagine, or minimally conscious state, and let's imagine that this patient may still suffer, no longer competent to make decisions, but still suffering. In this case, this argument can justify that you say, well, the patient is not asking us to die but simply because the patient cannot ask that thing to us. But if the patient was competent, was able to say anything, he or she would ask us to be killed. So because she is suffering, and suffering is bad, suffering must be avoided, must be spared to the patient, so the patient would be better off dead, even if there is no voluntary request of euthanasia. So the two arguments are different. Argument from autonomy and self-determination on the one hand justifies only voluntary euthanasia, but the argument from beneficence centers on the suffering and may also justify non-voluntary euthanasia. Now, the arguments against, it is very, very often said that an argument against euthanasia is that physicians must not kill, and you find it in the Hippocratic Oath. And they must not kill also because killing their patients would endanger the therapeutic relationship that must be based on trust. But to this, it has been replied, and I believe that this is convincing. First, that the fact that this is very clearly the traditional view does not imply that this is okay also for today, because today the scientific and technological context is very different, and also the social context is deeply different from what it was 1 or 2 centuries ago. And secondly, for example, Dutch people have declared that to know that their physician is going to help them to terminate their suffering is in fact strengthening the physician-patient relationship. It does not endanger it, but the Dutch people tend to trust more their physician when they know that the physician is going to help also with euthanasia. So this argument is probably flawed, but there are other arguments, and one of these is the fact that granting the option of euthanasia may risk to constitute an implicit pressure to avail oneself of such an opportunity once there is a law that accepts voluntary active euthanasia. Well, you know, there are people who are elderly, suffering, psychologically very vulnerable, perhaps they are alone. Now, these people who are mainly perhaps concerned with this hypothesis of euthanasia may feel a pressure to avail themselves of this opportunity, simply because this final choice is the easiest and most economic way to deal with the problem of their care, to give palliative care, to give care in hospices, to give home care for elderly people who are terminally ill is complex, is burdensome, is not cost effective, and so to accept euthanasia in the medical menu is something very, very expedient for the healthcare system, and this would put the dying in a sort of condition of having to justify their decisions whenever they simply decide they don't want to die. They want to go on living, even if there is little time left. In this way, the liberal idea of autonomy might risk being transformed into some form of coercion, even if an implicit form of coercion. Now, a third idea that has very often been pressed against the legalization of euthanasia is the risk of the so-called slippery slope. This argument simply says that once you accept very limited forms of killing, for example, only voluntary active euthanasia, then you will have a sort of inevitable sliding toward less acceptable forms. For example, we start with accepting only voluntary euthanasia, but then we are, in a sense, psychologically disposed to accept that people can be killed, and so some cases of non-voluntary euthanasia will be accepted eventually. And this seems the case with the Dutch situation. There have been empirical analysis that have shown that in the Netherlands they have more than 1,000 cases a year. Remember that the Netherlands is not so great a country, is more or less like Lombardy, for example, and they have more than 1,000 cases of non-voluntary euthanasia, even if the law very clearly says that only voluntary active euthanasia is acceptable. They have defined euthanasia in terms of voluntariness, but they have eventually accepted some cases, but I mean more than some, because more than 1,000 a year is a big number in my view. And moreover, there's also been a broadening of the net in accepting new cases. For example, they started only with adults. You had to have 18 years old. Only 18 years old could ask for euthanasia in 2002 when they started, but then they extended to emancipated minors, meaning the boys and girls from 16 to 18, and then simply to minors down to 12 years, and now they accepted to also for children in certain cases, for example, children of 4 or 5 years, and of course in that case it is not up to the children to make a request, but up to their parents. And this very clearly involves, in my opinion, a sort of a slide from the very clear case of a voluntary active euthanasia, in which you have an adult, such as DJ Fabo, who very clearly asks and is very clearly competent and is informed and all that stuff, to other cases in which all these conditions are not really present. We can also say something, and concluding with that, more specific as for physician-assisted suicide, because one can say these arguments which point to the social consequences of accepting voluntary euthanasia may be convincing, or at least may be convincing for some people, but one can say, but listen, physician-assisted suicide is different. Physician-assisted suicide is better than euthanasia. It is safer because, as we said, the agency is in the hands of the patient. So contrary to euthanasia, there is no risk of slipping into non-voluntary, the non-voluntary kind, because a physician-assisted suicide is always voluntary. So we have an assurance, a warranty that this act expresses the patient's autonomy, because it is up to the patient to make the final act. This is a possibly convincing argument in favor of accepting only physician-assisted suicide and rejecting voluntary active euthanasia. On the other hand, people who also object to physician-assisted suicide can note that the fact that one has a right to commit suicide, and no one denies that one has a right to commit suicide, does not entail that that individual has also a right to confer to another person the right to dispose of her life. I mean, if I kill myself is one thing, but if the law accepts that another person may kill me, it is a different thing. This means giving to another individual power over the life of another individual. And this may be doubtful. Second, one may object that the fact that someone is willing to cooperate, or at least the fact that someone will not be prosecuted if he cooperates, if he or she cooperates, may reinforce the individual's intention to die. And so we may anticipate some increase in the rate of the ratio of attempted suicide with this law, and this might be something that we don't want to. And thirdly, we can say, even if physician-assisted suicide is different from euthanasia and it is better than euthanasia and perhaps it is justifiable, then we may have a sort of slippery slope also here. That is, we start with accepting physician-assisted suicide and we say we just want that, but we don't want voluntary active euthanasia because it is much more risky. But then eventually we will be drawn to accepting also voluntary active euthanasia. This is not necessarily true. In fact, this can be discussed because, for example, in Switzerland and other countries, they only have physician-assisted suicide, and there is no real pressure to accept voluntary active euthanasia. So this is somehow doubtful. So finally, in my opinion, there are good reasons overall for being skeptical about voluntary active euthanasia. I mean, my aim was not to convince you, but this is my personal feeling, particularly because a general policy of withholding and withdrawing treatments has not been established yet in this country. I mean, we have this law, we've had this law for 4 years, but there is no general culture in medicine, in the society concerning the fact that we can refuse treatment. So I think we had better establish a very general policy concerning treatment before moving to things like voluntary active euthanasia. Also because the consequences of voluntary active euthanasia may be puzzling, at least for many people. Of course, physician-assisted suicide now must be accepted because the sentence of the Constitutional Court has said that Article 580 in that formulation is not acceptable, is not constitutional. So we must accept physician-assisted suicide at least in cases in which those 4 conditions are present, and I would suggest that sticking to those 4 strict conditions is a wise option. Definitely accepting voluntary active euthanasia as it would result from the referendum is unacceptable, in my opinion, is indefensible. But I'm sure that also people who the proponents of the referendum agree with this, because they, as I said, they say then the parliament will have to do a law. But this is a safe conclusion that accepting voluntary euthanasia in that way, in that very broad meaning, would be basically unjustifiable. Okay, I stop here, and now if you have questions, I'm very happy to listen to them.
I don't know if someone has some questions. I don't know. Okay. Anyway, I have just one question. I wanted to know if someone like leaves written, okay, I want to die, someone has to help me. If then someone helps him to die, like even as Cappato did with DJ Fabo, is still like under the law, can be convicted somehow?
I mean, sorry, if someone says...
So let's or let's read, for instance, I want to die, I don't know, like in an exit clinic in Switzerland, for instance. Yes. And as Marco Cappato, you bring him or she him or her at the clinic. Are you?
No, I cannot be convicted, of course, because the Constitutional Court has said that it is unconstitutional to punish me for helping you. At least if the four conditions that the court indicated are present. If those conditions obtain, then I cannot be convicted. Of course, if those conditions do not obtain, then it depends on the tribunal that you find, because there has been a case in Massa in 2020 in which the judge has ruled in favor of someone who had helped in performing physician-assisted suicide, an individual who was not dependent on life-sustaining technology. So one of the conditions set by the Constitutional Court did not obtain in that case. And so there was, so to say, a legal room for condemning that individual. But the judge decided that that was acceptable. So there is somehow an area of discretion by the judge that seems to be there, because the judge can decide in those conditions. But anyway, if the four conditions obtain, then I am not, I cannot be sentenced if I help you. Moreover, I did not mention this, and this is important for you as doctors or future doctors, that the Constitutional Court also said that the doctor has no obligation to provide the so-called treatment. When someone asks for physician-assisted suicide, then you have no obligation to provide the treatment. So this means that if you are, for example, if you as a doctor conscientiously object to physician-assisted suicide, you can just say, well, I'm not going to help you in that. You may perhaps refer the patient to another a willing colleague, but you're not under an obligation to provide the treatment, that is to kill the patient or to help the patient in terminating his or her life.
Okay, thank you. I don't know if someone has some other question.
Good evening, Professor. May I ask you, do you hear me?
Yes, but sorry, can you still see me?
I can't at the moment.
You can?
I can.
We see you, not your screen, but we can see you.
You can see me, but not my screen, because I can see no one now. My screen is blocked, and perhaps may I try to exit just one moment and select, because otherwise I can't see you. Okay, I just close for a moment and then I will be back in a minute. Sorry. Okay. Can you hear me now?
We can hear you, yes, but the screen is still blocked, but no problem.
So now I can also see you if you open your video. Who was presenting a question?
I was wondering about the. Excuse me, just I need to formulate correctly. Is gonna need a specific kind of doctor who is gonna perform euthanasia or whoever can do it. For example, I was thinking about abortion, just a gynecologist can do it. But euthanasia is gonna be performed by everyone, like a specific doctor, or also from a family doctor, surgeon, specialistic, or like this.
Very nice question. The sentence of the ruling of the Constitutional Court says nothing about that. But I guess that any doctor can do that because the wording of the article 580 does not even mention doctors. So the idea is that the wording is anyone who helps another in committing suicide. And so of course, any doctor, and any doctor can do that. And in principle, even any person. I mean, if I am not a doctor, but I am able to perform injections and may help my very old mother to commit suicide. And I guess that on the basis of the ruling of the Constitutional Court and on the basis of the article as it is now, I guess I could not be condemned. But of course, this is problematic, and this is one reason why the same ruling of the Constitutional Court very clearly said that the Parliament has to intervene, because the Constitutional Court has just given a very general principle, but then there are several elements that must be made much more precise. And one is this that you mentioned, for example, should we reserve this intervention to specific specialties? Should only the doctor who is presently taking care for the patient have the justification in killing him, or any doctor? I mean, it's not my doctor, the doctor that is curing me now, but another one, and also can't kill me. Is it a hospital doctor that can do that, or also family doctor that can do that? So many of these things should be much more clearly stated, and only the Parliament has this role, because the Constitutional Court does not make any law. It is the Parliament that makes the law, and the Constitutional Court can only decide whether the laws made by the Parliament are or are not acceptable from the point of view of the constitutional principles. So it is up to the Parliament to decide all these things, and they should do something. There are some proposals, law proposals, that are now being discussed in the Parliament, but I don't think they will have good results, because it is very difficult for all the parties to find an agreement on these topics, which are very divisive. I mean, people quarrel very much about all this area, these topics in bioethics in general, and end-of-life bioethics in particular.
So, Professor, I think we have just 1 minute left in the meeting. I don't know if somebody has a very last question, because otherwise the meeting is gonna close by itself.
Okay.
So.
No more questions.
No more questions. So thank you very much for your availability, and you explain everything very clearly. So thank you very much.
Thank you to you for your attention, and it was a pleasure, as I said.
Yes, thank you very much.
Congratulations for the initiative, and
thank you.
Auguri for your profession.
Grazie mille.
Grazie.
Buona serata.
Arrivederci.
Tanto, grazie, buonasera.